Welcome to Canadian Justice. I'm Christine Van Geyn. The COVID-19 pandemic is long over, but courts, employers, and individuals are still dealing with the fallout of vaccine mandates. Many Canadians were terminated from their jobs for refusing to comply with employer vaccine mandates, including when their jobs were entirely remote and work from home. A number of these employees have brought legal claims against their employers with varying degrees of success. One large claim by 473 unvaccinated healthcare workers in Ontario recently faced a significant hurdle, with the court calling their claim outlandish and ordering $190,000 in costs against them. But the court did preserve their ability to amend the claim. Now, while the focus of a lot of media has been on the failures like that case, there have been untold success stories. That's because many of these cases end up settling, and as a result, they're not reported on. When I read the case of the 473 healthcare workers, I noticed something. One of the plaintiffs in that case had retained a new lawyer who represented her separately, and the court allowed her claim to proceed, calling it a conventional claim as opposed to the other outlandish arguments made by the other claimants. And the lawyer representing this one plaintiff was Ryan O'Connor, a friend of the show who has represented countless clients in these untold vaccine mandate success stories. And Ryan is here today to talk about some of those stories. Ryan, thank you so much for joining me today. Let's start by talking about that large case, the 473 unvaccinated healthcare workers. What can you tell me about what happened to their claim and why your result was different?
Good to be with you again, Christine. The pandemic is long over, but unfortunately, the pandemic of bad public policy that resulted from COVID continues. I got involved in that case last summer, right before a hearing in August, which was seeking to have the claim struck. The defendants in that case, healthcare institutions, hospitals, and the government were seeking to strike the claim as not having a reasonable cause of action. I got involved in that claim on behalf of one client, and I had suggested that we take a more traditional approach. We remove claims about, for example, crimes against humanity, how mandates were a form of martial law, and that there was a conspiracy to concoct a pandemic, and rather present to the court a standard wrongful dismissal claim criticizing her healthcare institution's vaccine policy and and its response and its unreasonable and unfair termination of my client.
Is there anything you can tell us about your client's story in that case?
Yeah, the many of the other individuals involved in that case were unionized, so they don't even have claims. Unfortunately, their claims are struck and they won't proceed. But happily, the non-unionized clients will be permitted to seek court another day if they refile their claims along the lines that our client has. But our client was a remote worker at our healthcare institution, had started working there as a co-op student in high school, worked there for 25 years, has never had another job in her adult life, positive performance evaluations throughout. Unfortunately, she had some sincere faith-based reasons why she was unable to be vaccinated against COVID. She submitted an exemption request on that basis. Again, was a remote worker. Her exemption request was denied, and she was ultimately terminated. 25 years approximately of service gone down the toilet, and she wasn't offered a severance because it was unfortunately termination with cause. She's challenging that decision, and hopefully she'll be vindicated through the process. But as a remote worker, Christine, like the only virus she was going to be exposed to in the workplace was a computer virus. It is just completely asinine why she was treated that way, and we look forward to prosecuting that case now that we're permitted to do so.
So now that yours has sort of been singled out of that from that group as allowing to proceed separately, it doesn't have to be amended. What has the fallout been for the other plaintiffs?
So for the 400 or so unionized plaintiffs, the court has really foreclosed their ability to pursue something in court. I understand that many of them are seeking to appeal the decision on the motion to strike, but I believe that appeal will be dismissed. Those unionized employees, unfortunately, do have to proceed through the grievance process through labor arbitration with their trade unions. But for the approximately 70 non-unionized employees, again, based on the success we had for our client, those employees would be permitted to start individual lawsuits against their healthcare
Mhm.
institutions, their former employers, and hopefully seek recourse in that manner. We've been consulted by non-unionized plaintiffs that we didn't represent, and we'll be happily helping them with the process moving forward. So that's good news for them. They'll have their day in court and hopefully have their vindication.
Now, just very briefly, what do you think it shows about the importance of framing claims like these in a conventional way?
Well, you need to give the court a hook. And if you're talking about martial
Hmm.
law and crimes against humanity and Doug Ford committing a conspiracy with, hospitals
Right.
to terminate people, you're not going to get anywhere with the court. You're
Yeah.
giving it an opportunity and
Hmm.
opening to dismiss the lawsuit. So don't do it.
We've got to go to break, but we'll be right back. Welcome back to Canadian Justice, where we're talking with lawyer Ryan O'Connor about some of the untold success stories in vaccine mandate litigation. Now, Ryan, you've done a number of these cases, and I understand the details of some of those cases are pretty shocking and surprising. What can you tell us? What details can you give us?
Well, I can speak generally about matters that are before the court and not specifically about my clients, Christine, as you know. But I've seen cases, for example, where individuals who have complicated medical histories that prevent them from receiving any sort of vaccination, they provided, in one case, I'm thinking of provided medical exemption support from their specialists, from their family doctors, from local public health in one case. And yet that individual is still terminated from her job despite the fact that her job at a flu vaccine mandated, she was exempted based on the fact that she couldn't be vaccinated for anything. I represent an individual who, for cultural reasons, because she's an indigenous person, doesn't take any sort of medication, lives a more natural lifestyle, which is informed by her faith and her culture. She was terminated from her remote work position because she was unable to be vaccinated and therefore not able to comply with the policy. A lot of clients that I represent have sincere faith based reasons why they're unable to be vaccinated. They're practicing Christians, Jews, Muslims, and their faith informs their inability to be vaccinated against anything, not just the COVID vaccine. And yet, their reasonable requests for exemptions on the basis of human rights, the protection of their freedom of religion, have been denied. I've represented COVID recovered students who have had medical and religious reasons why they can't be vaccinated, but they're also young and they didn't need to be vaccinated against COVID. They had already recovered or they're otherwise healthy. And it was just for them a flu bug. These individuals were, deregistered from university and are seeking recourse. So I've represented probably about 60 to 70 individuals in wrongful dismissal cases and many university students and college students in these cases. But the stories are sad, they're shocking. And for for this to happen to anyone in the community just wanting to go to school or wanting to attend their job, especially for remote workers, the fallout is going to be long lasting for these people who've been unable to afford their mortgages, have lost their job, lost their livelihood, and frankly lost their ability to take care of their families. It's truly tragic, and we don't talk about it enough.
Yeah, and I think one of the things that we don't talk about is that in a lot of these cases, the employer, the university, to the extent that you've done student cases, they actually pay compensation to the to the person bringing the claim. These claims settle. So I think the mainstream narrative on this has been these claims are bogus. There's no case here, and that large case that we were talking about in the last segment kind of uh, fuels that narrative. But a lot of these cases actually, when you define success as a financial settlement, these are successful. What can you tell us about that? Like how many of these are actually settling that we just don't know about?
Well, most civil lawsuits in Ontario, Christine, as you know, settle. And employment cases have some of the highest rate of settlement in employment cases. An individual who's not union bringing a lawsuit against their employer for wrongful dismissal. What a lot of people don't know, COVID vaccine mandate or otherwise, is that it is incredibly difficult to terminate someone in Ontario if they're not unionized without paying them a severance. You can terminate someone for no reason, some reason, or even for a reason. But typically, and almost always, you do have to pay them at least their minimum legal entitlements, but oftentimes it's much more than that. There's a uh, there's one reason why we have not seen a single case go to court where a decision is rendered after trial in a vaccine mandate case involving a non-unionized employee, despite the fact that this has been ongoing for nearly 4 years. The answer to that is that there's been no case that's gone to court even though there's been hundreds, if not thousands, of these lawsuits, because presumably those cases are resolving. And while I can't speak specifically about cases in which I'm involved, I can say that there has been, in my view of these cases, there's been lots of success. Success ought not be measured by getting a favorable judicial decision. It's about achieving the right result for your client and for people that I don't represent who may have settled their cases. They've done so with the benefit of legal advice and hopefully have received some vindication in that respect.
What do you think the biggest misconception has been about these vaccine cases?
That persons who are unable to be vaccinated were out protesting every weekend of the pandemic, complaining about government, oftentimes rightly, I should say, given the pandemic overreaches. But what people don't understand is these are regular people. They're your neighbors, they're your family members, they're your friends, they're other students at school. Everyone has very personal reasons why they were able to be vaccinated and comply with a mandate, or were not able to be vaccinated. And there's no right or wrong answer about whether or not someone ought to be able to be vaccinated. These mandates in employment
Hmm.
context, universities were the only medical mandates that we've ever seen, certainly in my
Hmm.
lifetime, as a
Right.
precondition of being able to work or go to
Right.
school. These people
Ryan,
are normal
we've
people.
we've got to go to
Yeah.
break, but we'll be right back. Welcome back to Canadian Justice, where we're talking to lawyer Ryan O'Connor about some of these untold success stories about vaccine mandate employment litigation. And Ryan, you had talked about sort of this long list of reasons why people might have refused or declined to get vaccinated. And I think that there maybe has been some public misunderstanding about why people refuse and perhaps what the implications of what a refusal are and what is actually legally required under human rights legislation in order to obtain one of these sort of exemptions or refusals?
If someone, for example, Christine, has a religious reason why they're not able to be vaccinated. For example, maybe they're staunchly pro life and they object to the fact that vaccines are typically tested on fetal cell lines, don't contain aborted fetal cells, but are tested on fetal cell lines. And if someone is doctrinally pro life, they may object to vaccination on that
So
basis.
let me
There's a
just
misconception.
ask you there because I've heard this from a lot of people, and I know a lot of Catholics. Some Catholics have make that claim, and other Catholics don't. And I think that the Pope put out a statement about his view on the fetal cell lines. But what does the law say about that? Like, does the law get into parsing out theological beliefs, and what do you actually have to show to claim that?
I had this argument with one employer and one employer's lawyer about this very issue where I represented a Catholic individual who had a pro life objection. They said, well, the Pope said get vaccinated. And I said, that's not what the Supreme Court says in terms of whether or not that's a valid religious reason for requesting an exemption. The Supreme Court has said in a seminal decision in 2004 that one needs to simply assert a sincere faith based reason why they cannot comply, in this case, with an employment policy in order to validly request an exemption and to trigger the employer's duty to accommodate under the Human Rights Code. That means that the religious faith leader does not need to support the request. That the Pope, if you're Catholic, does not need to support the request, and in fact may interpret religious doctrine differently. Rather, it is a subjective analysis of the sincerity and that it's faith based and connected to the objection. And there's been a rampant misunderstanding in the public and the press, and frankly, even amongst lawyers, with all due respect, about when persons who have a religious exemption request ought to be accommodated.
Yeah, I think one of the things we need to think through is if you're asking a court to kind of cross examine a person on the basis of a spiritual belief, is that really the role that we want judges to be playing? Do we want um, courts to become arbiters of what is and is not a faith-based belief when they're debating the actual theology? I don't know that that's something that, I mean, the case law doesn't suggest that that's something we do. And from a public policy position, I don't know that it's something that we want our courts doing. What's your take?
Well, they shouldn't, and that's why the Supreme Court has set out a very simple test. The court is just to, or the Human Rights Tribunal is just, and the employer in these cases is just to explore the sincerity of the belief, not to challenge its validity. And if someone attends church regularly, leads a Christian lifestyle, and says, "Well, here's my Christian objection to vaccination," that's the end of the analysis. And unfortunately, many employers, in many cases that I've seen, they didn't even permit religious exemption requests, and that's completely wrong and a violation of the Human Rights Code. Now, that's some people said, I don't want to get vaccinated. That is a legitimate personal decision, and they ought to have been afforded the medical privacy and the respect to take that decision and to continue their employment or their education. But that's not something that's protected under the Human Rights Code. But also, someone saying, I have a religious objection is protected. And some employers are simply saying, well, that's a personal belief. Well, how dare you say that about someone's faith, something they practiced for their entire life? And unfortunately, there was a lot of mixed messaging about that, that employers got wrong and ultimately led to unfair, unjust, and wrongful terminations.
Now, do you think that the public opinion on this topic has shifted? You know, at the height of the COVID-19 pandemic, there was just so much hostility to people who did not get vaccinated. Do you think that that has changed? And do you think that a shift might impact how the courts think about this issue?
I think so. I think courts are not insensitive to public opinion and the tenor of the time. That's why we saw so many COVID cases being dismissed on procedural grounds, mootness, and otherwise. Because I think courts were just loath to get involved in a very politically charged environment, which was the debate about COVID policy. But these cases that are moving forward, I certainly see employers becoming much more amenable to being open to resolution at an earlier stage. We're seeing employers, terminate people over mandates still, but ultimately pay them severance, so doing the right thing. So I think that's largely been a response
Hmm.
to the public just having moved on from the
Hmm.
pandemic.
We've got to go to break now, but we will be right back. Welcome back to Canadian Justice, where we're talking to lawyer Ryan O'Connor about some of the untold success stories in vaccine mandate litigation. Now, Ryan, we've talked about how a lot of these cases are successful, where employees who were terminated and sue their employer for if they were not vaccinated and they were terminated, that these settle out of court. And um, another issue of that's one of the reasons we don't know about them. But another reason is that a lot of these plaintiffs actually don't want media attention. They don't want to talk about their case. And maybe you can explain why that is.
Well, I'll speak generally, not specifically about certain clients, but I can only imagine that the loss of a job. I represent so many individuals who have lost employment, are negotiating severance packages, et cetera. Nothing to do with COVID mandates. It can be it's very tragic for the family in terms of paying bills, but it's also something that's very private. Do you want to broadcast the entire community that you lost your job? You certainly likely, especially in the political environment we're in 3 years ago, would you want your neighbors, your friends, and family members to know that you were not in a position to be vaccinated, especially after the Liberals had just run a federal election dividing people on the basis of their vaccine status and maligning those who are unable to be vaccinated. And many people who are not able to be vaccinated, I say this from experience seeing these cases, have legitimate medical reasons and often very private healthcare reasons why they cannot be vaccinated. They don't want people talking about it. A lot of people just want to get what their due is, seek their severance, damages against their employer for inappropriate conduct, and call it a day. Which is certainly, again, speaking broadly about the legal dynamic here. This is, in my view, why not a single case has gone to court to a decision, because I think people just want their severance. They want to move on with their lives. They're not there to make a political statement. They're there to protect their privacy and move on, and good for them.
Now, one of the ways we've defined success here is employees got financial compensation. Either they received severance that they ought to have been paid, or they received damages against their employer. Can you give us a sense of what that financial range is? I know that there's a lot of factors that go into that, including how long someone had been employed with a workplace. But can you give us a sense, and maybe what's the top end that you have seen?
Well, these are, again, at their heart, normal employment law cases. And that was my philosophy in taking these on. When people started to be terminated over mandates in October 2021, there were very few lawyers prosecuting these cases. My strategy was treat it as a wrongful dismissal. So, what do we look at? We look at the person's age, their length of service, the type of job they have, and whether or not they can get a new job. We call those the Bardell factors. And if someone is saying, has worked for an institution for 30 years, they're 61 years old, and they were offered $0 when they ought to have been paid a severance, that person might get 24 months. That's typically the high watermark in Ontario for pay in lieu of notice for non-unionized individuals. But if someone's human rights have been breached, for example, they've requested a medical exemption from a mandate and that was denied, even though they had medical documentation, that would be typically a breach of the Human Rights Code. Damages can be upwards of $25,000 in that context. And there are other types of individual claims for potentially punitive damages, the employer acting in bad faith or otherwise that attract damages. But the high watermark in terms of pay in lieu of notice is 24 months, and that's dependent on the person's age and their length of service and those two other factors.
Now, I mean, obviously, one of the concerns is getting compensation for their clients, but what about other things like getting their jobs back or getting the policies reversed to the extent that they are still in force in some places?
Well, I think just the fact that, at least sort of my experience, that, we've brought claims against many employers, probably about 10 different hospitals in this province that still had mandates ongoing, at least the hospitals right up until recently. And I would hope that, the lawsuits that we brought on behalf of our clients, which are not only seeking compensation for wrongful dismissal, but if in every case have challenged the validity of the policy as being unreasonable. And I only hope that the more cases that employers and institutions see, they might say, well, it's just not worth it for us anymore. We're still on a two-dose mandate 3 years after vaccines started to roll out, and we're still being sued.
And
Perhaps
does that
this is
apply
a
to work from home employees as well?
yes. Yep. Yeah. I've represented clients who had a fully remote job and were required to test, but go into the workplace to go and get their testing kits to report their test results from
I mean,
home.
some bizarre
Obviously,
thinking there.
yeah.
Ryan, thank you so much for joining us and congratulations on the success for your clients.
Thank you, Christine. It's always good to be with you.
We've heard today about some of the untold success stories in vaccine mandate litigation. We know little about these cases because they tend to settle privately out of court, but they run counter to the mainstream narrative about people who refused vaccination and were fired. What do you think? Did these mandates go too far, or were they a reasonable response to the pandemic? You be the judge. Thanks for watching, and remember, a freer Canada starts with you.